Yes, sir.
Mr. Rosenthal, present in court, he appears without counsel. The state is represented by Deputy Richard Nemaha County Attorney, Mr. Angelo Ligori. Mr. Rosenthal, you're being provided with a copy of the complaint. This charges you with 4 counts of sexual assault of a child in the first degree. This charge is a Class 1B felony. Class 1B felony carries a maximum possible penalty of life imprisonment. There is a minimum penalty, mandatory minimum penalty of 15 years imprisonment if convicted. Count 1 is alleged to have occurred on or about December 22, 23, 2017. Count 2, December 29, 30, 2017. Count 3, January 12, 13, 2018, and count 4 between February 9 and 17 of 2018. Mr. Rosenthal, do you have any questions about what you're being accused of or the possible penalties? This time I'd like to review for you the rights that you have in regard to traffic and criminal proceedings. And if there are any others that have 9 o'clock matters, these will apply to your actions as well. Please bring any questions that you have about these rights to the court's attention when your case is called before the court. Each defendant has the right to enter a plea of guilty or not guilty, and the court can accept a plea of no contest. You have the right to be represented by an attorney throughout these proceedings. If you cannot afford to hire an attorney and there is the possibility of any jail time on a charge that you face, you have the right to have the court appoint or provide you with an attorney at public expense. You have the right to a trial. On misdemeanor charges, that trial can be to a 6-person jury if you ask for a jury trial within 10 days of pleading not guilty. If the maximum possible penalty on a charge you face is 1 year or greater, the court will automatically schedule that action for a trial by jury upon a not guilty plea. At trial, you have the right to confront and to cross-examine the state's witnesses. You have the right to bring your own witnesses before the court, and you can ask the court to order, that is to subpoena witnesses into court on your behalf. The defendant has the right to remain silent. You do not have to give any statement or any testimony. You can testify if you choose. Should you do so, anything you say can be used against you by the state. The defendant is presumed to be innocent. It's the state that has the burden of proving guilt beyond a reasonable doubt. The state must do so in a speedy trial, or charges would be dismissed. You have the right to appeal any final decision that's made by the court, and that includes the right to have a transcript, a typed-up record of proceedings which are being recorded. If you are not a United States citizen, a conviction could result in your removal from the United States or being denied naturalization if you would apply for naturalization. If a defendant chooses to plead guilty or no contest to a charge, then you are waiving. You're giving up all of the rights I've just discussed except 3. You still keep your right to an attorney, your right to appeal, and your right to remain silent in the future. Now, Mr. Rosenthal, because the charges pending against you are felony level offenses, you're currently in county court, you won't be asked to enter your plea before this court. County court does not have the authority to accept a plea or have a trial on a felony level offense. What you are entitled to in county court is a preliminary hearing. That is a hearing where the state must submit evidence to establish probable cause. Probable cause to believe that these offenses may have been committed, and probable cause to believe that you may have committed those offenses. If the state submits sufficient evidence to establish probable cause, or if it's your choice to waive your right to a preliminary hearing, then you would be bound over. The case would go to the District Court of Nemaha County, Nebraska, and it would be there that you'd be asked to enter a plea and where any trial would take place. Mr. Rosenthal, any questions about the rights that I have reviewed?
No, sir.
Mr. Rosenthal, do you wish to be represented by an attorney in this matter?
I don't have one yet.
Okay. And do you intend to try and retain an attorney, or do you think you may qualify for court-appointed counsel?
I may qualify over appointed.
If you wish to be considered for court-appointed counsel, you'll need to complete a financial affidavit. You can get that from the jailer, or you can get that from the staff today, directly across the hallway at the end of the hearing. You can submit that affidavit, and if you're shown to be qualified, the court will appoint counsel to represent you. If for some reason your income or your asset level shows you not to be qualified, you'd be notified that you would have to retain an attorney. Court will set this matter for a scheduling conference. Mr. Ligori, well, first of all, let me explain. The scheduling conference give you some time to determine if you can retain an attorney, if you're going to be appointed counsel, and then have you meet with counsel so that you can advise the court, yes, I want to have a preliminary hearing, or no, we're going to waive the preliminary hearing. It's going to take 15 minutes. It's going to take half a day, so that we can schedule accordingly. So that's what I'm setting now, is a scheduling conference. Mr. Ligori, any comment on setting that scheduling conference?
Never worked with the court schedule, Your Honor.
Mr. Rosenthal, I would be looking at Wednesday, August 18th to do that. It would be conducted by video. I will be on leave for a while, but I've got a judge covering, and they would do that by a video conference. Mr. Ligori, 2:30 on that date work for the state?
Yes, Your Honor.
Court will set a scheduling conference August 18th, 2:30 p.m. or soon thereafter, as may be heard by the court. Court will next take up the issue of bond. That is, what conditions are necessary to assure that you do appear in court to answer to further proceedings, and any conditions necessary for the protection of the public. Mr. Rosenthal, if you made bond today, would you live at the Lincoln, Nebraska address?
Most likely, sir, yes.
Are you currently on probation or parole?
No, sir.
Have you ever been convicted of a felony?
No, sir.
Are you currently employed, a student, or under an order of disability?
For something.
Mr. Ligori, any comments or recommendations that you would have for the court in regard to bond?
Your Honor, the state currently has Mr. Rosenthal charged with 4 counts. Sexual assault of a child in the first degree. I believe with the affidavit, it indicates another count of the same conduct in another county. So I think, considering the seriousness of the charges, no bond would be appropriate. If the court is considering setting a bond, I have reviewed some of the bonds set in this type of action, similar action, one in South Sioux City for child sexual assault, which one account bond was set at $1 million, and that was in March of 2021. And then in June of 2021, 12-count charge of child sexual assault bond in Omaha was set at $10 million. We have 4 counts. I believe at least a bond of $5 million would be appropriate here.
Thank you very much. Mr. Rosenthal, anything you would like to tell the court in regard to bond terms or bond conditions, including any comment on your ability to post a cash bond?
No, sir.
No comments? The court would find that some bond is necessary in this matter to assure the appearance of the defendant before the court. The court would set bond in the sum of $1 million cash or 10% postable by a deposit of $100,000. If you post the full amount, every dollar is returned. If you post the 10% amount, not even if you make every required appearance, not all of that is returned. 10%, or in this case $10,000, would be kept by the court as a bond charge or a bond premium. There would be a condition attached to this bond that, one, that you not leave the state of Nebraska without court authorization, written authorization, and two, that you have no contact with the alleged victim in this matter. Mr. Labore, anything else that you would ask the court to address at this time?
No, Your Honor.
Did you have any questions, Mr. Rosenthal?
That's fine.
Okay. You'd be remanded to the custody of the jailer pending bond or your next hearing. And as far as any application, you can see we've got your next hearing set for the 18th, so probably should try and get any application in within the next week if you do want to be considered for court. Okay, thank you very much. You'd be remanded.